The Western Cape High Court has dismissed Public Protector Mkhwebane's application to stop her impeachment process. At the same time, the presidency announced that she has been suspended with immediate effect on Thursday. UDM Leader Bantu Holomisa joins me now to unpack this further. Very good evening to you, Mr. Holomisa. Thank you so much for your time. A lot of developments. Of course, perhaps let's start with what your view may be surrounding the timing of the president's suspension of the Public Protector. It happened a day after she announced that she would be investigating the Phala farm allegations. Surely the president's decision is not unexpected.
Hello,
Mr. Holomisa, were you able to hear me? I was just referring.
You are saying surely what?
Surely the president's decision is not something that was unexpected.
Yeah, it's true, but at least he should have been aware that he was one of the respondents in court. And for him to have been asked by the Public Protector last Friday to respond to the allegations, serious allegations which happened in his farm, that request was made by one of the political parties, the ATM in Parliament. And for him to have said yesterday that he is suspending her, notwithstanding the fact that the matter was still in court, to me it looks like it was a contempt of court, procedurally speaking, because the judgment was due to be given today. It's fine, the judgment has been now given. But the Public Protector has got many options. This case is not going to, or this issue is not going to go away very soon. If I were to advise the Public Protector, I would say that given that there are two cases which she was tasked to investigate. That is the Glencoe, as well as the issue of the president's farm break-ins. So in that way, I'm sure if she were to go and challenge the president in a court of law, she would have a strong case in that she would say, at the time I challenged this process, nobody was aware that there was a Glencoe scandal or the Glencoe issue, as well as the Phala gate. So she would mount a strong case to say, I'm dealing with a conflicted individual here. How I wish that the president would have delegated this matter to his deputy or any other person, because South Africans are not blind. They know that the Public Protector and the president's spat emanated from the time, started from the time when she found that the CR17 fund campaigns and so on. This thing is deep. But anyway, we have taken note of the court decision.
Yeah, because...
Yes, we've taken note of the court decision as the UDM. We are not questioning that. But what you need to do as a journalist is to clarify for the public as to what is the judgment around the intentions of suspending Public Protector as she filed those papers with, I think when she filed those papers citing the president, that she has no leg to suspend her. Given that, underline, given that there's no inquiry in Parliament which has started. I challenge anyone live on TV to tell us that the inquiry on public protector has been started in Parliament.
What do you believe to be the intentions then?
I am not interested in that.
But you posed the questions, General.
I'm arguing procedural issues. We will talk about substantive issues when the time is right for them.
Yeah.
Do you know any inquiry which has been started in Parliament?
No.
Yes, thank you.
So a full bench says Advocate Mkhwebane is accountable to Parliament and that there's a strong public interest in the continuation of the impeachment process. I mean, telling, it's a full bench that has made that announcement.
I don't query that.
Yeah.
Not at all. I fully agree with that judgment. There is a public interest here. Yeah. But we must be careful of giving a judgment before the process has started.
So, in handing down the judgment, Judge Nathan Erasmus said that the judgment was based on the facts before the court at the time the case was heard and up until an amendment was made to the notice of motion after the hearing.
That is his right to say so, but Mkhwebane has got a right also to appeal to the next court to verify the authenticity of that judgment.
So perhaps let's go back to what the statement from the President's office said when it was, when the President was fleshing out some of the reasons. I mean, he says the documents that were given were quite substantial. It says that the President has fulfilled his obligation to provide Advocate Mkhwebane a fair hearing by according her sufficient time and opportunity to make submissions. Do you think the process was fair?
The process might, in terms of timelines, it might be fair, but the President himself is conflicted, unfortunately, in this process. So that's why I was suggesting that it would have been better if the President has given the whole matter to his Deputy President.
The other matter here is that, I mean, as you speak about the President giving the matter to his Deputy President, we also know that there was also reference to say that the matter that the Public Protector has raised about the President, I mean, that big announcement that she'll be investigating the Phala robbery debacle, will be handed to the Advocate Mkhwebane's deputy. So it doesn't mean that that process has essentially stopped.
That on its own raised some questions. Why was the President rushing to want to suspend her after she gave her notice under her signature to say, can you respond to this? Where do you draw the line? Especially when you talk about decided cases on conflict of interest. So we won't buy that nonsense.
What do you want to see happen?
What we would like to see happening now is that the inquiry must start in earnest. And then if the President has preempted or has acted wrongly, and even the Speaker wrote to the President long before the inquiry has started, that's prejudice. That's prejudicial. So this whole thing needs to be reviewed by the committee. But if they insist they want to investigate the matter, it's fine. I'm sure the public protector will come with her lawyers and start the process. But procedurally speaking, the whole thing is flawed. I'm not a lawyer. I'm just an ordinary soldier who is understanding the procedures of Parliament. This is not on. You can't make laws just to with retrospective effect to target a certain individual. That's a bad law as a matter of principle.
Very well. Thank you so much for your weighing in on this topic and also giving us your view as the UDM, that's UDM President Bantu Holomisa.